Hello and welcome back to our video updates. It's Sade here. Today's video is going to discuss some questions related to bankruptcy in the context of claiming excess proceeds. But this video will also actually work for people that have questions in general about how bankruptcy might affect money that somebody receives in a certain time frame, either before filing the bankruptcy or after the bankruptcy has already been filed. So let me dive into it and explain why I'm doing the video. We get a lot of questions from asset locators, heir finders, or beneficiary locators, people that find money that people didn't know about. Maybe it's related to an inheritance, maybe it's related to real estate that the heirs inherited, or maybe it's related to excess proceeds after the sale of real estate by a lender or a tax agency or taxing authority. And sometimes it could also be unclaimed funds from a death benefit that's sitting with the state. And then the other thing that could potentially happen is somebody just has questions in general because they're thinking about filing bankruptcy and they are wondering if certain activities on their bank statements might affect their eligibility to file the bankruptcy or affect the outcome of the bankruptcy itself. Now, I am not a bankruptcy attorney. I used to handle bankruptcy cases for a short amount of time, and that was years ago. So I'm not a bankruptcy attorney. I would suggest that if you are thinking about a specific situation that's specific to you, you should certainly do a consultation with a bankruptcy lawyer. However, this video is going to give you somewhere to start, something to start thinking about, and just general tips on how things would work. When somebody is filing a bankruptcy, it could be a natural person filing the bankruptcy, or it could be a company filing the bankruptcy. In this video, I'm mostly talking about the Chapter 7 bankruptcies and the Chapter 13 bankruptcies because that's what most individuals would file. And for those people that just need a quick recap, the Chapter 7 is the type of bankruptcy that you can file if you do qualify. You have to pass the means test. So the means test, there are some calculations that are done, and they look at your income, your expenses, and your debts and things like that. Now, if you don't qualify for the Chapter 7, then you would be forced to do a Chapter 13 or drop the matter altogether. A Chapter 13 is a different kind of bankruptcy because it is a repayment plan. The Chapter 7, on the other hand, is an absolute complete discharge of all the debts. And I would like to qualify that because when I say all the debts, we know that not every single debt would be dischargeable in bankruptcy, right? So the IRS liens and also some student loans are not able to be discharged in bankruptcy. But all the other things that are able to be discharged in the bankruptcy, they will be discharged under Chapter 7. So Chapter 7 bankruptcies usually take only about 4 to 6 months. As long as all the paperwork is filed, the trustee is satisfied with the paperwork, and you have the 341 creditors meeting, and everything goes well, then it will be discharged and everything will be done. Chapter 13, on the other hand, takes maybe 3 to 5 years, and some might actually take longer if there's a need to recalculate the payments that are supposed to be made to the creditors, or let's say the plan changes because the debtor needed a change or had a change in circumstances. So it's typically 5 years for the Chapter 13s. Now, that means that somebody could potentially be in a bankruptcy for quite a while and still have an inheritance that's pending or some unclaimed funds out there that they didn't know about. And so the question in this video is, what happens then? Can the person go ahead and claim those funds without any repercussions or without having to mention anything to the bankruptcy court? The bankruptcy law itself is a federal law. Now, each state has their own exemptions that somebody could also use if the person is in that particular state, as opposed to using the federal exemptions, or you could also mix and match them. So each bankruptcy case would have a trustee that's overseeing everything that's filed to make sure that there's no abuse of the bankruptcy protection laws, that the debtor is not abusing the bankruptcy law, and also they check whether the creditors are also abusing the bankruptcy laws, because some creditors would file exaggerated claims, or they overinflate how much they're actually owed, and the bankruptcy trustee will challenge those types of things. If the debtor looks like there's some misrepresentations or some discrepancies in the document submitted and the actual application, then the trustee would also challenge the debtor and ask for additional clarification and give them a chance to correct the thing, to amend the petition and things like that. So that's pretty much the role of the trustee. And the 341 meeting that I mentioned is the creditors meeting that typically happens in the Chapter 7 cases. And that is for creditors to show up and examine or challenge or question the debtor and put up any objections that they like in person. If it's done in person, or if it's done by Zoom, then they appear and question the debtor a little bit more and try to challenge the filing. So typically everything goes well in the 341 hearing, and then the debts are all discharged. So the way that the bankruptcy works, for those that are not familiar, is that somebody puts in a petition for the protection of the law, saying that I don't have enough money to meet my obligations. I don't have enough money to meet my debt obligations in addition to my ongoing monthly expenses. And therefore I need to get help to be able to write them off, the ones that are able to be written off. And so that's usually what people file for. Well, it's typically the Chapter 7 because it's more attractive if you don't want to have to repay the debt. And most people may not even have the resources to actually repay the debts anyway. So that's the whole point of the Chapter 7. When they don't qualify for the 7, as I said before, then they might be forced to do a 13 where they repay the debt, but not to the full amount, not to the extent of the actual amount owed. The plan is created in conjunction with the debtor's attorney as well as the trustee, and the trustee, the bankruptcy judge will have to approve that plan. The trustee approves the plan, and then the judge would approve the plan. And the plan would be based on what is the disposable income left over after, regular monthly necessities are met. And then whatever is left over will be divided amongst the creditors in order of priority. And it depends on whether the debt is secured or unsecured, right? So the secured creditors have priority over the unsecured creditors, and the credit card is unsecured debt. So my payments will first go to people that have a lien against maybe my property, because that's secured, real estate or some sort of collateral, and that would go to them first, and then whatever is left over will go to the unsecured creditors. And the percentage is determined based on what I have available. So they don't all get 100% of what they're owed. They might get maybe 20 to 30% of what I actually owe them, and they'll get that for a period of 5 years usually. And the court requires certain things to be listed out inside the petition itself, and the bank statements of the debtor, some of those documents, the debtor would produce bank statements usually looking back 6 months. Some trustees don't actually dig into the bank statements, line by line, to verify to see whether the petition matches up with the bank statements. Some do, depending on what kind of vibe they're getting from this particular file in general. And a lot of the trustees will only go back 3 months. And the reason why they go back, it's called the look back, is to see whether there were some fraudulent transfers made before the person filed for bankruptcy, or whether there were some preferred payments made to certain types of creditors. So a fraudulent transfer could be that I had money in my bank account, but then I took all that money and transferred it to my cousin, just so that when I'm filing for bankruptcy, it appears as if I don't have money, and I would then qualify for a Chapter 7. And that could be a fraudulent transfer. The other kind of transfer could be fraudulent in terms of real estate. Sometimes people transfer those types of assets or other assets and give it to a family member. Maybe the property is worth $300,000, and on paper I say that I sold it to my uncle for $5,000. So that looks weird. It looks inconsistent, and so the trustee would dig more into my file as opposed to somebody else's file that looks clean and pretty straightforward. So when they look back, they're allowed to look back 6 months. The thing to keep in mind is that trustees can do what we call a clawback, which is to go back in time to try to get back the money that I fraudulently transferred, or if they're able to prove that, they will get that property back or get the money back and put it into the bankruptcy. So whenever somebody files for bankruptcy, there is an estate created. You know how when somebody is deceased, there's an estate created, because when we file a probate case, we file it under the estate. In the bankruptcy court, the estate is a bankruptcy estate. I'm submitting my records and my finances to the mercy of the court. So I create an estate, and the trustee has that power to dig into that and collect things back for the estate, claim things back for the estate, and do that clawback that I mentioned. So that typically happens after a lot of investigation and maybe a couple of hearings. The other general rule in the context of bankruptcy is that the law says that anything that happened within 180 days of the date of filing is fair game for the bankruptcy estate. So that means that if I filed a bankruptcy in January of 2021, the trustee is allowed to look back, right? Remember the 6 months, that's 180 days. And then they can actually also look forward. So let's say my bankruptcy is still ongoing and I never knew at the time that I had unclaimed money with the state, or maybe I didn't know I had unclaimed excess proceeds, and somebody contacts me and tells me about it. Can I claim those excess proceeds in the month of May because my bankruptcy is still pending? Well, the answer is yes, I could claim the excess proceeds, but I'm required to actually report it back to the bankruptcy court, because the petition asks me to list any ongoing claims, any anticipated claims, any accounts receivables, and also requires me to regularly update that information if any new development happens. So the moment that I know that I'm owed some money by the state, or potentially owed some money by the state, I'm supposed to tell my bankruptcy attorney, and my bankruptcy attorney is supposed to update that in the records with the bankruptcy court. And then there's a second layer of examination which looks to see whether there's an exemption that I could claim for those monies, right? So I could potentially claim an exemption. Sometimes people have personal injury claims that are ongoing or that pop up in the middle of the bankruptcy, and a lot of states have special exemptions for at least a percentage of the money received for personal injury claims. Now, for inheritances, it could be reachable by the trustees. So it's best to always speak with a bankruptcy attorney before you do anything at all as far as actually taking active steps to claim the money. I think that a lot of people could argue plausible deniability, because if they hear about it but didn't do anything about it, perhaps there's not a great duty to report it, because they haven't really taken it seriously. They haven't signed any agreement with any locator. So this video is to tell you that in some counties, the county itself actually requires somebody to fess up. They ask whether the claimant is in bankruptcy currently. And they ask that so that they know that they have to inform the trustee, the U.S. trustee or the bankruptcy trustee. So that's why you'll notice that some counties ask for that information, and some lenders actually also ask for that information in order to release the excess proceeds from a mortgage foreclosure sale. The lenders, it's lender by lender. So some don't really care to ask that kind of information, and some do. So if they ask, obviously the claimant has to be honest about what's going on. I have a bankruptcy pending. Yeah, you have to say that. And then if you are actually claiming the excess proceeds, you should talk to a bankruptcy attorney before you do the claims, and see if it's going to be seized by the trustee, for the bankruptcy estate and given over to the creditors. So that doesn't really benefit the claimant in that sense, because you will get your locator fees, but the claimant might lose all that money to creditors anyway. So for a quick recap, so that you can have some takeaways that are easy to remember, when somebody files for bankruptcy, they're supposed to report any pending claims, any potential receivables, and things like that. So of course, if they know about the excess proceeds or a possible excess proceeds that they could claim, really they're supposed to talk to their bankruptcy attorney about that and see if it's needed to be reported. And then the other thing to keep in mind is that if somebody has already started the process of collecting those excess proceeds and thinking about filing bankruptcy in future, it's best to wait a little bit, if it's possible to wait a little bit, because otherwise the trustee might go back into the bank statements and see that money and try to collect it for the estate. So that's another thing to keep in mind. And the third takeaway I think is that while a bankruptcy is pending, is not really the best time to claim excess proceeds or claim any inheritance or claim any unclaimed funds, because it has to be reported to the trustee, and the likelihood is that there might not be an exemption to cover everything, and so the claimant is going to lose money to the bankruptcy estate, which would then go to the creditors. So I guess it's okay because perhaps the person really owed the creditors and needed to pay those debts. But if the goal is to claim the maximum amount for the claimant, then while the bankruptcy is ongoing, it's not the best time. And I wanted to also say that the way that you know whether a bankruptcy is done is that it's either going to be discharged or dismissed. And so you can ask the claimant to check to make sure that it was discharged or dismissed before they start trying to claim any money from the county, from the lender, from the state, things like that. And last but not least, the final thing to think about is the fact that the trustee is allowed to also consider anything that happens even after the bankruptcy filing. So the person has to time that bankruptcy really well if they're going to try to avoid having the trustee collect those monies. Well, I think that covers everything and summarizes what we went over. People have a duty to report, and they should be reporting, especially if the bankruptcy has already been filed. The person has a duty to report, and the person should definitely talk to a bankruptcy attorney so that they don't do anything criminal while trying to claim this excess proceeds. And you as a locator have that duty, of course. Just to me, I think you as a locator also has that duty to not mislead people or give them the wrong suggestions. And so you should always defer to the bankruptcy attorney if you come across some scenarios like this. So remember, the type of money is not as important as the timing of it. And then even after that, possibly the bankruptcy attorney might be able to find some sort of exemption, but it's not likely for these excess proceeds or the unclaimed funds or any types of death benefits. The bankruptcy court will usually collect that as part of the estate of the debtor. So that's all I have for you today. I wanted to put this together to explain to you how important it is to make sure you get that consult with the bankruptcy attorney so that the claimant is not doing anything illegal or something that could impact them negatively, or doing something that will cause them to lose all that money that they just found out about. And so I hope you like the video. If you do like it, please give us a thumbs up. So hopefully this video has shed some light on. So as you can see, it's a lot of different layers, a lot of intersecting and interacting and overlapping issues that could affect the final outcome. But I wanted to put this out here as an educational tool, something to get people thinking in the right direction and not doing anything that could be considered criminal or that could affect your life or your bankruptcy filing itself. So that's why I put this video together. And if you like the video, please give us a thumbs up. And if you like the channel, remember to subscribe and please hit that bell so that we will notify you of our future videos. Thanks and have a wonderful weekend.